Hello, good evening, everybody, and welcome to the London branch midweek webinar. Thank you all very much indeed for investing your time with us this evening, and welcome to our speaker, Andrew Eben. Andrew is going to talk to us today, as you can see, about safety as our #1 priority and foreseeability from the expert's perspective, which already has developed a little bit of intrigue, Andrew. So without further ado, I'm going to hand over to yourself and to do an introduction. The only one other thing is Andrew said he's quite happy to take questions as we go through if anybody has something on a particular point. So please do drop that into the chat box and we'll endeavour to pick it up. Thank you all. Up to you, Andrew.
Thank you very much, Greg. Good evening, ladies and gentlemen. The heading wasn't meant to be either provocative or intriguing. It's just that twice in the last fortnight, senior managers have made the comment, and you hear it all the time in all sorts of industries: safety is our #1 priority. And you look around and you think, no, actually, making money is your #1 priority. Safety is something you know you've got to do, and it's generally seen as a pain, and it's a cost. But inevitably, people say it is our #1 priority. And what I really wanted to do by way of example was to look at two specific cases that we've been involved in, where the question was posed to me, both of them criminal cases, and I was acting in one case for the defendants, and in the second case I was acting for the Crown. And the question was asked of me as part of the investigation: were these foreseeable? Could they have known this was going to happen? So that's really where the title came from. From a personal point of view, I've worked in the leisure industry for over 40 years now. I joined Edinburgh City Council in the 1970s as a lifeguard. I was out of work. And for those of you who are as old as I am and remember the bronze medallion, I had a bronze medallion and someone said, well, see if you can get a job as a lifeguard. My mother was appalled, and actually it changed my life completely. I worked as a lifeguard. I went to Loughborough University and did a degree in sports science and a postgraduate degree in education. And then I joined the Royal Life Saving Society. The upshot of which was that following guidance published by the HSE in 1988 on safety in swimming pools, I was asked if I could put together a program for pool lifeguards, because there wasn't one. And one thing led to another, and I worked for the society over the years for 14 years. I had a spell with Birmingham City Council as a principal safety officer for 5 years, and I now work for Quality Leisure Management as an associate consultant, and I work as a freelance consultant with my own company. So what do you need to be an expert? Do you set out to be an expert? I certainly didn't. I spent a number of years developing pool safety procedures, looking at lifeguard training and things, that sort of thing. I knew my way around a pool. I'd done it from both ends, if you like, but I didn't set out to be an expert. Does it just happen? Well, in my case, I think it did. I took a phone call one afternoon during the summer in 1990, and a chap introduced himself and he said, we're investigating a number of spinal injuries, all happening in the same pool, and we understand that you are an expert in spinal injury management in the swimming pool and in spinal injury rescue. And I wouldn't have called myself that, but I said, yeah, okay, I could do that. And he grilled me a little, at the end of which he said, that's fine, Mr. Eben. So you're fine to go to Hong Kong on Sunday. And at that point, I just went blank and said, okay, very funny, who is this? And he said, gave me his name, and he said, we are Privy Council agents acting for the Hong Kong government, because Hong Kong was still a UK protectorate at that point. Can you go to Hong Kong on Sunday? You will be met. Turn up at Heathrow Airport. British Airways desk, they will give you a first-class ticket to Hong Kong. There will be a car to take you to a hotel. And I was absolutely flabbergasted. So was it something that evolved over time? For me, I suppose, yes, it was, but it did just happen. And that's really how I got to where I am now. And over the years, I guess I spent initially probably only 30% of my time doing accident investigation type work. Whereas now I probably spend 80 to 85% of my time doing that sort of work for prosecutions, for coroners, solicitors acting for defendants. So it's a very broad base, but I do specifically focus on the aquatic environment and particularly swimming pools. So my role as an expert witness in some ways is dictated. From the criminal perspective, it's very much a forensic approach. There is an organization to which I subscribe and belong called the Society of Forensic and Expert Witnesses. And that has evolved on the basis of most of what we do is forensic work. We are searching and investigating what led to a particular set of circumstances. The Crown Prosecution Service have a very clear view that if you're working as an expert, whether you're working for them or you're working for the defence or you're working for the HSE, it is to help the court achieve their overriding objective, which is to come to a particular decision on guilty or not guilty. It's to give an opinion that is objective and unbiased, and the objective and unbiased element is really very important these days. Certainly I've been involved in 3 or 4 cases, both civil and criminal, where an expert brought in by the other side has clearly written a report that he believed the people paying him wanted to hear. And in that respect, you have to challenge. In one case, we did challenge the QC leading the prosecution objected to the expert's report because he said it's neither objective nor unbiased. And importantly, you have to focus only on matters that are in the expert's specific expertise. And it certainly is in one case, in the middle of a prosecution following a near drowning in a pool. It led to a QC for the defendants turning on me and saying, well, that's all very well, Mr. Evan, but what makes you an expert? And I just looked at him and said, and we were talking about the role of the lifeguard, and I simply looked at him and said, and then looked at the judge and said, well, with due respect to counsel, Your Honour, I wrote the book, which in this particular case was very much the case. I did write the book. And he sat down at that point. But the CPS have a very clear view on what experts should be doing. Are you an advisor or are you a witness? Anyone with specific knowledge can be an expert witness if they choose. In the criminal environment, they have to be given permission to act by the court, and the same is true in the civil environment, that one side or other will make an approach to the court to say, we wish to appoint an expert, this is who we wish to appoint, these are his or her qualifications, and the court has to give permission for that to actually happen. You provide an impartial and an independent opinion, and in a couple of cases that certainly caused me some difficulty where I've had to turn around to the people instructing me and to say, I've done my report, you're not going to like it. But it has to be impartial and it has to be independent because that's what the court expect. But perhaps most significantly, the expert isn't an advisor. The advisor has a duty to the person who gives him or her the instructions. As an expert witness, we have to sign a declaration that says that we understand that our duty is to the court and not to the party instructing us. And that is something that, again, is focused on occasionally when things get difficult, when evidence is being given. So leading into these two particular cases, the first one is a swimming pool, in as much as it was an accident in the swimming pool changing room. And it involved after school activities where the pool had been hired to a local swimming teacher, and she had for a number of years run a regular learn to swim program. It's a very successful program, it was always busy. The problem arose in that there were unsupervised children on the premises. The pool was relatively old. The pool side was very narrow, so the school had insisted that unless you were actually teaching or you were in the water being instructed, you weren't in the pool hall. If you wanted to watch and there wasn't an observation balcony or windows or anything like that, the only place you could watch from was from the door at the entrance to the changing room. And it was a logical thing to say, because if any of you have taken your children to the pool for lessons, all too often the parents want to get up close and personal. They want to see what's going on. They want to talk to the teacher about why is their child doing this, that, and the other. That's incredibly obstructive for the teacher, but in pools where space is tight, it can be quite hazardous. So it was the right decision for the school to have made. They were charged with a health and safety offence, to which they pleaded guilty. And it was at that point I was then instructed, and I was asked if I could write an expert report in mitigation of the situation that had arisen, to say that I understood that they pleaded guilty. I think reading between the lines, they were pleading guilty because, for those of you who have been in court, whether as an observer or as an expert, there is a discount for pleading guilty, and it makes a lot of sense, particularly when the fines are likely to be high. So they pleaded guilty, but the defense barrister wanted me to essentially talk to the court about, yeah, they were guilty, but they've got all these other things in place. They've got an unblemished record, and all of these things should mitigate the size of the fine. Ultimately, I suppose to some extent you could say, well, it worked because we were dealing with a fatality, although it was only a child, and that sounds terribly crass. But experience has shown that the life of a child is not as valuable as the life of a breadwinning adult. So the fine was just under 17,000 with £12,000 costs, but still a lot of money for a school that was a trust. It was an academy. It had its own budget, and to suddenly lose the best part of £30,000 out of your budget isn't something anybody had planned for. So the fine was a challenge. They had good arrangements for use. There was no question about that. Private hire, there was a contract for hire. It was a regular activity. The company who ran the swim school had signed the contract, and they had reflected in the instructions to parents, when their parents signed their children up for lessons, a number of the requirements that the school had placed on them in terms of their contract. So it was well documented. There was no question about that. Conditions of use had been issued by the school who hired out the pool, and again, they were reasonably good for the sort of activity that was taking place. I think it's always the case that you could drive some pretty big holes through any of these things if you're looking at it from an expert perspective. But by and large, it was difficult to really criticize the actual conditions. The supervision requirements that were issued to the school, issued by the school and then passed on to the parents by the swim school, were quite detailed. And as I said earlier on, parents weren't allowed at the poolside. If they wanted to watch, they had to do it from the entrance to the changing rooms. And this is, as a typical example of your average sports hall swimming pool changing room. But in this case, it all went horribly wrong because there were two children who were in the changing rooms unsupervised. And they, for reasons that we never really got to the bottom of, they decided they wanted to scale one of the blocks of cubicles. And this was the same cubicle as the one that caused the problem, but this was one from the ladies' changing room. So they were unsupervised. The parent of one was teaching on the poolside. So immediately, the swimming teacher was in breach of her own conditions for use, because she was a parent, her child was going to join the next class, but she couldn't keep an eye on her child because she was teaching on the poolside. The second parent was standing at the door watching the lesson because the deceased's younger sibling was in the pool. So they were fooling around. They climbed up the locker bank and it started to move. The bank of lockers fell backwards, and it was on a little wooden plinth to keep the bottom of the lockers clear of the pool, the changing room floor, because of the water. So it started to move. One of the children managed to jump clear. The other fell back underneath the lockers. The child hit his head on benches that were in the middle of the room, which, again, if you think to perhaps school days or having used school pools, there are invariably benches in the middle of the changing room with coat hooks on a frame above them. So the child fell back and the locker came down on top of the child. That's the locker. It's obviously been picked up at this point because the paramedics had to turn it at least onto its end to allow the child to be rescued. But the same situation could arise in a whole range of different environments. I mean, these are just two photographs taken from our local library. And there are plenty of others. Stacks of equipment in a sports hall store, stacks of equipment that members of the public in a gym might use. And I'm sure for your various environments, you could come up with lots of similar examples. So the rub of the whole thing was, should they have seen this coming? Was this accident foreseeable? The starting point for me was to have a discreet word with a number of colleagues to see if anybody had come across this type of accident. I hadn't. I'd got no records anywhere in the UK to show that this type of accident had occurred in a sports hall or a swimming pool changing room. And one or two colleagues came back and said, we haven't either. There have been one or two things where something has failed, but not under these circumstances. So was it foreseeable? We thought probably not on the face of it. So it then came down to, if it wasn't foreseeable, why are the prosecution bringing a case? And what could the school have done about it to prevent it having happened in the first place? They were charged with a single offence under the Health and Safety at Work Act, under Section 3, failing to ensure the health, safety and welfare of the non-employee, that one. And part of their argument was that there had been no adequate checks on the stability and the security of the locker installation over a 6-year period. And that, in fairness, was documented. I mean, the school couldn't get out of that one, although they argued in their defence that as part of the sort of routine walk round the sports department, the head of department regularly checked on the condition of lockers, and we did have evidence to show that they had reported damaged doors and damaged locks, sort of things we regularly see in sports centres. But in terms of documentation on actually checking that the lockers were intact and secure, it hadn't been done. They hadn't got, and the HSE really majored on this, they hadn't got a suitable and sufficient risk assessment relating to lockers falling over. And when we argued that for there to be a suitable and sufficient risk assessment, there has to be a significant hazard. And at the school, this had never happened before. And as far as we were aware within the leisure industry, it had never happened before. Did it constitute a significant hazard? The HSE's engineer that they brought in from HSE Labs argued that the lockers were a fatal accident waiting to happen it was inevitable that this was going to kill somebody. And when we said, well, prove it. Where is your evidence to say, well, it's bound to happen, which of course they couldn't do, but there wasn't a risk assessment. The staff hadn't been trained to undertake risk assessment, and that was a problem. The head of PE said, well, I did do a risk assessment training course, I think, some years ago, and under a bit of pressure, she said, well, it was probably 12, 15 years ago, but I haven't actually done any structured risk assessment training. But she had completed all the risk assessments for the PE department, and she had used as her source of information and templates guidance that was published by the Association of Physical Education, and in their Safety in PE handbook, they provide reams of templates for all of the different sorts of activities that take place in schools. And they also identify some of the significant hazards that that arose, but they hadn't been trained. Was that an issue? When you looked at the depth of information that was in their risk assessments, we didn't believe it was a significant problem. But in fairness, they hadn't actually had any specific training. The difficulty that we then found was that within the guidance from the association, it talked about checking the stability of furniture. And the court had a lengthy debate as to whether or not a bank of changing room lockers constituted furniture. We argued that potentially it could, but there wasn't actually any guidance either way. There was nothing in any of the guidance published by HSE or any of the leisure organisations on locker stability. So it was difficult for a school to then turn around and say, well, we can't have not followed the guidance because there isn't any. The HSE said they'd failed to maintain the lockers, and this is why they fell over. But the defence were able to show that 72 hours before the accident, the head of PE had actually submitted a repair order to the school's maintenance team to repair doors on some of the lockers and to repair a damaged door into the changing room. So it was quite clear that inspections were being carried out. And they'd failed to consider children playing in the risk assessment that, of course, didn't exist. And we said to the HSE's expert, well, hang on, if you're saying there wasn't a suitable and sufficient risk assessment, how can they have failed to consider children playing in the risk assessment because there wasn't one? But against the background of this never having happened before, was it reasonable to prosecute them for failing to consider children playing in a non-existent risk assessment? It then begged the question that we posed to the wider leisure industry. And at the end of the day, I mean, somebody said to me, why do you do it? Apart from making money. And I said, well, okay, that's how I earn my income. Why do I do it? I do it because we can always improve the way we operate. And I say that in absolute sincerity. If I didn't believe that by doing this sort of work, we couldn't make a difference, I wouldn't do it. Because that's really what it's about. And the wider message that we sent out through QLM, through our newsletter, was to say to people, go and check that your fixtures and fittings around the building are actually properly secured. And our local gym, I spoke to one of the duty managers and said, are your lockers secure? Will they fall over? And he just looked at me. He said, well, of course they are. I said, have you checked? And he said, well, no, but why would they fall over? And it was a very valid question. Why on earth would they fall over? So in part, it was about what can we do to prevent this sort of thing happening again, because it matters. So the second thing that came to light was that when the HSE went in and the scenes of crime officers went in and took photographs, the wall that these lockers were fixed to had got 5 holes at the top, which are in this top photograph. And when you looked at the top of the bank of lockers, there were 5 brackets, and it didn't take a work of genius to discover that the brackets exactly lined up with the holes in the wall. Which then begged the question, why weren't they screwed down? Why weren't they bolted in place? The facility to do that was there. So taking the sort of lead from our forensic approach, the investigative bit went right back to, well, when were the lockers installed? What are we looking for? Well, we're looking for a set of RAMs on how this work was done. And it transpired that back in 2013, the changing room had been refurbished. New lockers had been put in. We had the specifications for the lockers. We had the instruction manual for the installation of them. And we had a statement from the company that manufactured them, who are a well-known locker company and still comfortably in business, to say, well, this is how it's done. And we had a note to say that the work had been inspected, because at that point, the school was still part of the local authority. So the local authority had inspected the work and the lockers were installed correctly. So why did they fall over? Who took the screws out? Because there was plenty of evidence to show that they'd been screwed in. The rawl plugs were still in the holes. And when you looked closely at the rawl plugs, it was quite clear that they had been used. So somebody had taken the screws out. But the same could apply in our industry to pieces of gym equipment, items of rescue equipment on a poolside, the creche, the local play centre, anything like that, where items are screwed to the wall to hold things. So, was there an inspection regime? If there was, what did it include? What we discovered was that 2 years before the accident, the changing room floor had been looking, shall we say, a little tired, even though it had only been down 5 years. A company was brought in to relay the floor with a water-resistant sort of linoleum type finish. And they said, well, we can get the tiles up, we can just relay, or we can relay this finish on top of the tiles. So it was decided they would take the tiles up. And there was debate about, do we move the lockers so we can lift the plinth that the lockers sit on? Or are we going to lay the linoleum up to the level of the plinth and then use a silicone sealant round it to keep the water out? The decision was taken that the floor would be laid up to the plinth and the plinth would be left in situ with the lockers in situ on top of it. It then became quite clear that in the course of doing the work, the company who did the work had decided it was going to be much better to take the lockers off, lift the plinth, lay the floor underneath it and put the plinth back on top, because it was going to provide a more resilient surface. And as a principle, I have to say to the defence, I actually agree with that. So I said, we need to get the company in that, we need to get someone from the company in that can tell us what they did and why they did it. We got to a point where the UK Border Force became involved, because it transpired that the guy who'd done this work had skipped the country. The UK Border Force were able to show when he'd left the country, and there was no record of him having returned. And we were never able to trace him. So we really didn't understand what the rationale was for doing the work the way they'd done it, when that wasn't their instruction. But it then became clear that if they'd moved the lockers, they'd obviously put them back, and at some point in the process, they'd forgotten to put the screws back in. With no screws in and 2 9-year-olds hanging off the doors of the lockers, there was a not insignificant turning force applied to the locker bank, and it toppled over. it wouldn't have toppled over if they'd been properly secured. So the school was in a very, very difficult position, because we argued that as far as they were concerned, the lockers had never been moved since they'd been installed. They'd been installed correctly and had been inspected. The lockers themselves were routinely inspected because doors were replaced and locks were replaced. And they had no reason to believe that anything else had gone on. From their point of view, was it foreseeable? And my answer was, in this situation, I don't think it was. There was no reason to suspect that anything was wrong. And if the company or the swimming company that were hiring the pool had been on top of the way that parents were managing, looking after their children, the argument was that this would probably never have happened. So we didn't believe it was foreseeable, and I think we eventually concluded that the courts took a reasonably sympathetic view of that. But they had to tighten up their inspection regime. And what were they looking for? Well, if they'd got wall-mounted equipment, who's checking that it's actually secure? And this, of course, applies in any commercial enterprise. It doesn't have to be a swimming pool. It could be a storeroom. It could be coat hooks in the entrance to an office. If something is screwed down, it's been screwed down for a reason. And therefore, if it's going to be used, somebody periodically should check that it's happening. Does the inspection include this sort of thing? Or is it presumed, as was the case with the school, that, well, actually, why is it going to move? It was put in properly. We checked it. What do we need to check? Can we even get to the screws? Who installed the items? Were they installed by a qualified professional? Or was it Fred because he's a good bloke and he's got a screwdriver? And then most importantly, from our point of view, when we're conducting any sort of accident investigation, is there a paper trail? In this case, have you got a paper trail showing how these items were procured, that there were risk assessments and there was a method statement for the installation process, the work had been signed off, and in all three cases, we had the evidence to show that this was the case. And then were there routine inspections? Yes, there were. But those routine inspections didn't involve trying to pull the lockers over. We were critical of the HSE, who said, well, what you have to do is you get a big screwdriver and you ram it between the wall and the back of the locker and you try and prise the lockers off the wall. And we rather took objection to that and had to say, hang on, that is a destructive approach. If they weren't loose before, they will be by the time you finished inspecting them. And HSE weren't terribly happy with the way we put it to them, but it was a matter of fact. If you try destructive testing, you can be pretty sure it's not going to work afterwards. Is the work monitored? And who's monitoring it? The estate manager at the school said that periodically, when he went round to do a sort of estate survey, he put, I think his words were something along the lines of, I put my not inconsiderable weight against the side of these and tried to push them. And they didn't move. But of course, he was pushing them laterally. He wasn't trying to pull them at 90 degrees to the way they'd been fixed on. And if people are monitoring, do they know what they're doing? This is not a setup picture. I'll tell you where it was, but I know Lee Simmons, who's joined us, probably does know where it was. This was a stage set up in an indoor arena for a concert. The lighting crew had been in, they put the lighting towers up and all the associated equipment. And the duty manager went round with one of their engineers and said, right, well, we'll just check everything's ready. And he found that. And he just looked at the engineer and he said, are you having a laugh or what? And I said, oh, I have no idea how this happened. Well, you don't need to be a rocket scientist to work out that whoever put this in was a complete idiot. But it is about monitoring, and this is back to why do we do this? Well, we do it because we're trying to make, it sounds a bit glib, the world a safer place. But we do this sort of thing because we feel we can make a difference. Because there's no question in my mind that would have collapsed at some point, because it had got a complete lighting, one end of a lighting rig on the top of it 30 feet up. So the monitoring process is as important, and it's one of the things that we routinely ask to see. Are you checking what's going on? Because if you're not checking, you can't prove what's happened. The second one I want to look at, which is a swimming pool one, how good is your water? As in, how good is your swimming pool water? Water quality was something that was a major contributor to a prosecution that went to court only last year. It was one of the first cases that went to court after lockdown, involving a 4-year-old child. Private hire a week-long camp at an outdoor activity centre. They've got a swimming pool booked for occasional use. There wasn't a formal agreement. They'd been there before. It was a regular thing that they did every year. The father took his 3 children into the pool. The son, who was 4, he thought had got out of the pool. That was our first problem. What was the father doing to lose sight of his 4-year-old? The child was later on found on the pool basin floor, and it was a number of hours later. In the intervening period, the pool covers had been put back on the pool. They'd been taken off again. A 1-hour-long swimming lesson had taken place, and they still hadn't found the child. And it wasn't until they searched everywhere and someone said, well, we'll check the pool again. And somebody got into the pool and effectively tripped over the body. The directors pleaded guilty to a health and safety offence, and they were fined £60,000 plus costs. It was a deal struck with the enforcing authority. Primacy initially was with the police, and it was handed over to the local authorities' enforcement officers because the police were comfortable that it wasn't a crime as such. A deal was done that they would plead guilty to a health and safety offence if the Crown dropped a corporate manslaughter charge. The barrister involved in the prosecution and I had both said, this is without question corporate manslaughter. When you investigated all the things that were wrong, it was endemic. But a deal was struck, partly, I think, to get a guarantee of a guilty prosecution. They ran this camp every year. The pool had got a coded lock, but everybody knew the code. In previous years, the pool had been lifeguarded. On this particular event day and for this particular week, a lifeguard hadn't been provided. The activity organisers hadn't been told that and presumed it was as the previous year. The member of staff who was on duty said, well, no, I'm only here to lock up, mate. So they thought they'd got a lifeguard, but they hadn't. And the pool water quality was, to say it was poor is being kind. We measure we measure water clarity in nephelometric units. And as you can see, the smaller the number, the clearer the water gets. The one on the extreme right has a nephelometric unit value of 10, and that looks pretty clear. In swimming pools today, particularly when we're putting computer drowning detection and things like that in underwater cameras and things, we look for a value of 0.5, which is crystal clear. So when you go swimming, I would imagine you would all probably say, well, that's what I expect to see. I go into my local pool for a swim. That's what I'm expecting to see when I walk onto the poolside. You're not expecting to see that or that. The drain cover was damaged. Somebody had put a plastic pipe in the drain cover. They put a bucket on the top of it to stop kids getting their fingers into it, which immediately reduced the ability of the thing to circulate the water. And It transpired, again, during the course of our investigation, that this was not uncommon. It's actually the first time when I've looked at pool water readings that I've found a column that actually comments on the clarity of the water. And if you look down the list of the third one from the left, you'll see it says cloudy on most occasions. To the point that when it was actually showed as being clear, someone's written a little smiley face and gone, yay, because it was so unusual. But that and a number of other things were really the triggers for us to say, corporate manslaughter. This is not just a health and safety offence. This is so serious. They had no risk assessments for swimming. They've got no structure for their pool plant operation. The pool plant room was an absolute disgrace. There were chemicals all over the place. It was a series of accidents waiting to happen. In terms of testing, we looked at 17 readings over a number of days. They didn't record all the tests that they did, so they couldn't prove anything. 5 out of the 17 indicated clear water, 11 cloudy, and 1 said, well, it was clearer. We weren't quite sure what that meant, but essentially on only 5 out of 17 was the water potentially of an acceptable quality. The free chlorine, the chemical we use to disinfect the water, levels should be around 1.5 to 2 parts per million. They varied from anything to 1 to 6. The more chlorine you put in, the more uncomfortable the water becomes. And we had witness evidence from both users and, in fact, the swimming teacher who did her own water test because it was such a problem, to say this was an ongoing problem, particularly in the summer. The other contributory factor was the child hadn't got, well, child couldn't swim, and he hadn't got any swimming aids. The child had been given, this isn't him, this is just a picture off the internet, it's actually an American one. He'd been given a buoyancy jacket. Buoyancy jacket complied with the relevant European standard, but not for a 4-year-old. And we have the photographs of the child in the jacket, taken by chance the day before. And it did look like that. There's no way it would have actually worked. And one of the things with swimming aids is that the European standard requires that a young child should not be able to take the jacket or the device off without assistance. It's got to have 2 separate maneuvers to take the thing off them. That's not the case with one of these. You can open these with one hand. What they should have had was armbands or similar. They were allowing swimming to take place. They knew they'd got non-swimmers attending. The pool was very deep. It was short. It was over 1 meter deep at one end, and with steps going down to it, and it went down to just over 2 meters at the other end. It was like a ski slope in the middle. But they had no facility to make sure that non-swimmers were wearing the appropriate swimming aids. It's not as if the information wasn't available. And one of the arguments for the defense was, well, they didn't know this sort of thing. Well, I'm terribly sorry, but if you are operating a swimming pool, or you're operating any commercial concern, ignorance is no defense. And I'm sure it's a comment that you've heard lots of times. You operate a swimming pool, you need to find out what you need to know. And they hadn't. There's a European standard for swimming aids. This is off a contemporary one. There's just been an update to it. And we will actually start to see, of course, with us having left the EU, we'll start to see this on all sorts of items. Armbands, interestingly, are PPE, because for some rather bizarre reason, when the PPE directive was being written, and we've never understood why, somebody wrote armbands for swimming instruction into the PPE directive as a specific item. So armbands are PPE, so they will in the future feature a UKCA mark. But the child had got a buoyancy jacket on that was too big. He could take it off quite happily, and again, we have photographs of him running around and standing at the top of the steps into the pool without his buoyancy jacket on. The father had no idea where he was. They didn't have access to the right sorts of swimming aids. And the water quality was, as you saw in the pictures, so awful that there was no way you'd really see to the bottom of the pool. And if you'd put people into the pool and the water was disturbed, there was absolutely no chance of anybody seeing something that had gone to the bottom inadvertently. So we were quite confident in how we were going to deal with it. I say we were somewhat preempted when they offered us, sort of, as the Americans would say, a plea bargain. We'll plead guilty to health and safety if you drop the corporate manslaughter approach, which was, was okay, I suppose, but I'm not sure it sent out necessarily all the right messages. Other things that we picked up, Legionella. Their Legionella testing program was pretty ropey, and you only had to look at the condition of the shower head and the mixer tap to see that they'd got a problem with hard water, but they'd got no evidence to show what they were actually doing about it. Not in the same place, but again, the sort of thing that we would pick up, both from a health and safety audit perspective, but also as when we're doing expert investigations. An HSE inspector said to me many years ago when I was with Birmingham, it's not that you don't want us coming in. We'll come in if something has to be looked at. The problem is you don't want us to look at anything else, but we will. And it's the same when we're doing an accident investigation. An expert will look at something and say, well, that's not right. And of course, if you see one thing that's not right, you start looking at other things. And so the evidence starts to build. This was actually the reason we were uncomfortable with this was the sign at the back is the bit that we've blown up on the side at the right. To be kept clear of goods, bins, rubbish, and other obstructions, because it was actually the disabled refuge. Now, I mean, Lee obviously knows, and one or two of you I've met before know I'm a wheelchair user. And I said to the general manager when we were in this building, so if there's an evacuation, where do I go? And he said, we go into the disabled refuge. So I can't get into it. It's full of bins and all the other rubbish. And he just stood and looked at me. And immediately, your hackles are up. You start looking for other things. I didn't go in to look at this at all, but this is one of the things I found. Electrical problems we keep coming across. This again was picked up as part of an accident investigation. We'd had a fatality in a pool. Inevitably, as you're walking through changing rooms onto poolside, you're looking at other things that are there, information, signs, notices, hair dryers that are always out because everybody's using them. And if you're a geek like me, you stop and look at the hair dryers. And I found that. That had been tested the previous week and passed as safe. And again, you just think, what's going on? In the same building, we saw that at the reception desk, and then worse, in one of the offices, that was a live installation. And the manager said, well, it's not really a problem. It's all RF. It's all Ethernet and stuff. And I said, funny that I didn't know Ethernet cables had 3-pin plugs on them. We weren't there to look at that, but this is what happens when you go in. And I just harked back to the words of my friendly HSE inspector who said, you'll do it, your eyes will be everywhere, and then you're on the offensive. And then just to draw things perhaps to a close, one or two things that we've picked up in saying people keeping out of court. What is the message we want to try and get to people when we've done these investigations? The wider message. Have you got suitable and sufficient risk assessments for what's going on? Are they up to date? Have you got, and are you implementing your safety operating procedures? Have you got induction and ongoing training? And most importantly, and certainly in our industry, it's where we get very uncomfortable. Are you assessing people's competency at the end of both induction and their training? Too often we say to people, can we see the induction records? Yeah, they're fine. They've all been signed. They're dated. Can I see the competency assessment? And they said, well, they've signed them. No, they've simply signed to say that you gave them a piece of paper and they were there to receive it. How do you know that they actually took on board what was in that induction or training process? Well, they've signed to say they did. No, wrong answer. They signed to say they were there. Training is of absolutely no value if you don't confirm that people have actually got it right and they understand what they've done. So when we're doing expert investigations, these are the things that we are always asking to see. Equipment testing, monitoring procedures, maintenance procedures. Are they up to date? Are they written down? Have you got the audit trail so that we can see that you are actually doing what you say you're doing? Who's checking on the staff when they're at work? It's not Big Brother, but it is written down in the Health and Safety at Work Act in Section 2, supervision. And invariably, when we are investigating accidents, one of the things that we find is that people are not really checking up on what's going on. Again, I go back to when I first started as a lifeguard. We never knew when the general manager would appear on the poolside. And when I left to go to university, I went and said goodbye. And I said to him, we never knew when you were coming. He said, well, that's the point. He said, I wanted to be able to say, hand on heart, I know what's going on in my building. And the best way of doing that is to get out on the floor now and again to make sure that what should be happening is happening, and it's happening the way that people have been trained to do it. So monitoring staff when at work is crucial, particularly I think in leisure where people are often working relatively remotely. It's not as if they're just in an office. They could be anywhere in a building. What's the housekeeping like? Is it clean and tidy? Certainly in the leisure industry where it's very public facing, you walk in through the front door and you expect the place to be pretty well spotless. Even older buildings, there's no excuse for poor housekeeping. But what's it like below stairs? What's it like in the plant room, the staff room, storerooms and things like that? Because that's where it really tells, and that's invariably where it can go wrong. Is there evidence of action being taken when areas of concern have been reported? Something's wrong. Has somebody done something about it? And just to finish off a last slide, we have to say it's not tongue-in-cheek at all. This is what we found. This again was part of a fatal accident inquiry. And we'd gone to look at the way the pool had been operating. It then transpired when we were interviewing witnesses, and again, we were acting for the Crown. And we spoke to one of the staff on duty who had said, oh, I walked into the pool. We got a problem with our dosing equipment for the chlorine. Right. So every so often we do a test, and if the chlorine levels were low, we'd walk onto the poolside with a bucket of chlorine, granules in this case, and we'd chuck it in the pool. But hang on, other people, oh yeah, the people in there, we just tell them to move to one side. Well, how long has this been going on for? When did the plant system break down? Expecting them to say, well, it was yesterday. Oh, 6 weeks ago. So you've been operating like this for 6 weeks. Can we see the plant room? We walked into the plant room and it was a disgrace. They'd got live exposed cables dangling in one area. Where are your chemicals? Well, they're in the chemical store next door. So we opened the door, and this is my colleague standing in front of me. This is what we found. And in fairness, I've seen far worse. It really wasn't too bad. Stuff was labeled. There was a cosh folder. It was reasonably tidy, apart from, say, the boxes and things on the floor. But then when you went behind the door, we never really discovered what the panda was for. They'd got all the right stuff, but why on earth would you have a panda in the chemical store? And we've never come up with an answer for that. The actual environmental health officer specifically asked for an explanation in writing, and they're still waiting. So I hope that perhaps gives you an insight into the sort of thing that I do. My colleague Lee Simmons does similar work. particularly where we're looking at accidents in the sports industry, let's say in my case in the swimming pool industry. I did go to Hong Kong, as it turned out, for 10 days. And at the end of it, we were successful in a $20 million series of personal injury claims. And I've just been asked if I would go to Hong Kong again. And I've said, well, is it safe from a COVID point of view? And more importantly, is it safe politically? And the solicitors have come back and said, well, I think actually we could do the first stages of this remotely by video rather than you coming out, which sort of suggests that perhaps it's not quite the time to go to Hong Kong. But it's an incredibly varied role that we do. Lee and I went out to Spain 18 months ago now to look at a pool where there'd been a catastrophic spinal injury. We were retained by the defence, and it takes you everywhere. It is a fascinating area of health and safety, and it's one that I'm very passionate about. But I hope it's given you some indication of the sorts of things that within leisure we do as expert witnesses. Thank you very much, and I'll take any questions if there are any.
If you have any questions, do pop it in the chat function. Greg, I will hand over to you.
Brilliant, thanks, Suzanne. Hello. Well, I was right in my introduction, Andrew. That was both fascinating and intriguing. Thank you very much indeed for that. I have a question for you, slightly more broad, but it's since the introduction of the new sentencing guidelines in 2016 for health and safety, food safety, and corporate manslaughter. Have you seen, or how have you seen these affect court proceedings and what we are now seeing with regards to judgments?
It's had a massive impact. Just before the guidelines were, and it's interesting they called them sentencing guidelines, but the caveat to it was to judges, ignore these at your peril almost. I went on a course just before they were enabled, and it was run by a QC who gave us a live case. He said, this has just been tried. They sentenced last week. It was somebody who'd lost a hand in a factory in Leicester. The fine handed down was £11,000. He said, right, I want you to all go away, apply the new sentencing guidelines and come back with a figure. And there were 30 people present, and we all came up with figures somewhere between $250,000 and 300,000. I think in the leisure industry, the worrying thing we're finding is that people are saying, oh, of course, it doesn't really apply to us because we're a charity. Well, actually, it does. You're a business. You've got a bottom line. It does apply. The courts, in certainly 2 cases that I've been involved with, have taken probably a more lenient view than they would have done before, because the trust was a charity and they are doing this for the good of the community. But we are starting to see bigger and bigger fines being handed down. And I think in most respects, it sounds perhaps a bit harsh, but I think it's right, because too small a fine sends out the wrong message. Way pre-guidelines, but there was a fatality in a pool in the Midlands. 2 lifeguards were individually prosecuted. One, he wasn't found not guilty, but the judge ordered that the case against him be dismissed because the jury simply couldn't agree and said they would never agree. But on the other one, he was found guilty, and he was given a £200 fine. The guy that died was in his 40s. He was the breadwinner, and the HSE were up in arms. And the judge privately afterwards said there was no point in handing down a bigger sentence because he couldn't have paid it. He's lost his job, he's lost his marriage, he's lost his house. He hasn't got any money. So what was the point of fining him any more than £200? We said, all very well, but that sends out all the wrong messages. It almost says it doesn't really matter. And we are now starting to see, certainly in leisure, bigger fines coming in. And I think that is right. I can't remember, there was a figure, HSE did publish a figure last year on it. And I can't remember what the figure was, but there's a cumulative health and safety fines within leisure were racking up rapidly.
Yeah, I know from the general HSE stats, I think they went up from the pre-sentencing guidelines level 14, 15. There was, I think, total fines for health and safety offences were around about 18 million. And I think they went up in 18, 19 to just under 80 million. So they have increased significantly. I've got one other question that's come in. Is in your experience, do you find the approaches of the HSE and local authorities consistent or not, as the case may be, in terms of their accident investigations?
In the environment in which I work, generally, yes, they are consistent. I think the challenge is not so much from the HSE's point of view, but from environmental health's point of view, is getting them to recognise early enough when they don't have the expertise. I've certainly from my point of view, I've found I've been brought into cases fairly late on in the process, and there's stuff you look at it and think, really, I wish I could undo this because it's the wrong approach. Not catastrophically, but overall, yes, I think their approach is broadly pretty similar now, because the guidelines that are out there, the swimming pool, particularly the swimming pool guidance that's out there, is now well known. So they've actually got a common starting point. I have to say, I haven't really had to, other than the school lockers, I haven't had a row with an HSE inspector for a while now.
That's good to hear. Well, thank you also for that, and I hope that answers the question. I don't know if we have any more questions, Suzanne, that have come in. I'm just conscious of time as well, as we've gone slightly past 7 o'clock.
Yeah, no more questions. It's just a lot of feedback just regarding your presentation, Andy. That's found it really, really helpful. It was excellent delivered. So just like to thank you for a very, very informative presentation.
It's been my pleasure. Thank you for inviting me.
No, that is a pleasure. Thank you very much indeed. I'd like to endorse that, and just thank everybody else who attended this evening. I hope you all were echoing those sentiments, and just to wish you a very good evening, and to let you know that the information for next month's event will be out shortly. So thank you all, have lovely evenings, and look forward to seeing you at the next branch meeting.
Thank you very much.
Good night.
Bye.
How do I stop it?